So again, any questions about the content of the program or anything else, please email me. With that, Luke, we're turning it over to you, and we're delighted to have you here.
Thank you, Jeff. Thank you for the kind introduction. Thank you to all the sponsors for putting this together. And thanks everybody for being on the call. My talk today is called The Most Compelling Religious Liberty Cases on the Federal Docket. And I'll cover three main topics. First, I'm going to start with the four biggest cases at the Supreme Court right now. Three of those are closely related. They're being heard this term: Carson versus Macon, Kennedy versus Bremerton, and Shirtless versus City of Boston. I think of them as the funding football and flags cases. And those three cases kind of involve free exercise and free speech balanced against the government's interest in enforcing the Establishment Clause and separation of church and state. And then the fourth case at the Supreme Court right now, 303 Creative versus Ilinis, involves a balance between free speech rights and non-discrimination laws. So I'm going to start with those four big cases at the Supreme Court right now. Just kind of give an overview of the arguments on both sides and kind of big picture where they fit into the court's jurisprudence. That's the first part. Second part, I'm going to turn to a couple lower court cases that present very important issues that are likely bubbling up to the Supreme Court in coming terms. One involving religious hiring by religious organizations, and one involving minority religious freedom, Native American rights to use sacred sites on federal land. So that'll be the second part. And then third, I just want to zoom way out and look at the big picture of religious liberty litigation and jurisprudence and ask a few big questions, like where is the Supreme Court headed on religious liberty right now? How do all these cases relate to each other, and what comes next? So that'll be the three parts. And then I hope to leave plenty of time for question and answer. So let's just jump right in with the four big cases at the Supreme Court right now. Got a few slides just to kind of break up the monotony since we all have a little Zoom fatigue. First case pending at the Supreme Court right now, Carson versus Macon. And this case starts in rural Maine. And here we have a picture of lovely rural Maine. And what you don't see in this picture is very many people or any public school buildings. There are a number of school districts in rural Maine that don't have public high schools. And so what does the state of Maine do about that? They have a state constitution that requires them to provide a public education, don't have any rural public high schools. Maine has set up a program where it will reimburse or pay tuition up to a certain amount at the private school of any parent's choice. So parents can send their child to any accredited private school, even schools that are out of state or out of the country. So for example, some parents have sent their children to the Taft School in Connecticut, this beautiful, high quality private school. But there is one very important condition on this program. Maine will not pay tuition at any school that Maine deems to be sectarian, which it defines as promoting a religious faith in the curriculum. So the Carson family wanted to send their kids to a religious school. Maine would not pay the tuition for that school, and the Carson family has sued the state of Maine. And the question in the case is fairly simple. Is Maine violating the Constitution, violating the Carson family's free exercise rights by offering to pay tuition at a wide variety of private schools, but excluding schools that promote a religious faith? Now, to understand how the Supreme Court is going to address this question, it's helpful to look at kind of the broader sweep of the Supreme Court's First Amendment jurisprudence. And I have a very modest goal of giving you 60 years of Supreme Court First Amendment jurisprudence in 60 seconds, looking at some different eras of the Supreme Court's Establishment Clause jurisprudence and how it treats funding for religious organizations. So the first era started in the 1940s when the Supreme Court first held that the First Amendment applies to the states. And this was an era of strict separation, ran from the 40s to the 80s. And basically the Supreme Court said that aid or funding to religious groups is forbidden under the Establishment Clause because it advances religion. This is a view of strict separation of church and state. It's where we got the metaphor of the wall of separation of church and state making its way into Supreme Court jurisprudence in cases like Lemon versus Kurtzman, where we get the famous Lemon test that is often used to assess Establishment Clause issues, and the Nyquist case, which actually held that providing tuition for use at private religious schools violates the Establishment Clause. In the late 80s and running through the 2010s, the Supreme Court kind of gradually shifted to what might be called a neutrality posture toward aid to religious organizations. And this is the idea that aid to religious groups may well be permitted under the Establishment Clause, as long as the aid is neutral, that is available at both religious and non-religious organizations, and privately chosen. So the aid is directed through private choice, like parents choosing where they want to send their kids to private school. Leading cases from this era: Mitchell versus Helms in 2000, Zellman versus Simmons Harris in 2002. Zellman upheld a voucher program in Ohio that allowed parents to use school vouchers at both non-religious and at religious private schools. Now, in more recent years, since around 2010, the Supreme Court has started to move toward what I'd call more of a non-discrimination posture toward aid to religious schools. Under this view of the First Amendment, aid to religious schools is not only permitted under the Establishment Clause, but may well be required by the Free Exercise Clause if the government is also giving aid to non-religious groups. So the idea here is if the government gives aid that you can use at non-religious institutions, but says you can't use it at religious institutions, that might violate the Free Exercise Clause. And the two leading cases here, Trinity Lutheran versus Comer in 2017 and Espinoza in 2020. And those two cases are worth a closer look because I think those are the cases that are going to get the most airtime in the Carson case at the Supreme Court right now. So first, Trinity Lutheran versus Comer in 2017. There, the state of Missouri had a program where it would provide grants for nonprofit organizations that had playgrounds, and they could use the grants to resurface their playgrounds using shredded tires. Basically, a government grant program to make playgrounds safer. And these grants could be used, any nonprofit could apply, but the grant program excluded any nonprofit groups that were religious. That was challenged as a violation of the Free Exercise Clause, went up to the Supreme Court. The Supreme Court held, I think it was 7-2, that the government cannot discriminate in this aid program based on religious status. If it cuts you out of the program because of your religious status, that violates the Free Exercise Clause. There was a footnote, though, suggesting, is this limited to tires? Is it limited to like safety programs? Like, surely the government, has to provide fire service at both secular and religious schools. So is this just about safety, or does it also extend to education itself? And that was the question in the next case, Espinoza versus Montana Department of Revenue, decided in 2020. There, Montana had a program for reimbursing tuition used at private schools. It would allow the tuition used at private secular schools, but it wouldn't reimburse the tuition if you used that tuition for a religious school. And that was any school affiliated with a religious organization. Supreme Court took that case, basically extended Trinity Lutheran to schools and said, doesn't matter whether it's tires or schools, the government still can't discriminate based on religious status. There was some language in Espinoza, though, that left open the question, what if we're not cutting people out of the program because of religious status, their affiliation with a religious group? What if we're cutting them out of the program based on the religious use of the funds? They're using the money to inculcate religion in their school. That is the key question in Carson. The state of Maine says, we're not cutting off your grants because of your religious status. We're cutting it off because you infuse religion through your curriculum. And so we should be distinguished from Espinoza. This case was argued in the Supreme Court several months ago. I think oral argument suggests that the court is likely to extend Trinity Lutheran and Espinoza to distinctions based on religious use, and basically likely to hold that Maine is violating the free exercise clause by denying tuition funds to the Carson family because they want to use those funds at a religious school. So what are the big takeaways from the Carson case? I think the first takeaway that we should all get from this is just kind of recognizing that shift in the Supreme Court's jurisprudence over time from the strict separationism of Lemon and Nyquist in the 70s to the neutrality of Zellman around the year 2000 to the more non-discrimination posture today. That's been a major shift in the court's Establishment Clause jurisprudence, and it has a lot of practical effects. I would also argue that this shift is a good thing. It better comports with both the history and the purpose of the Establishment Clause. I think the strict separationist view of the Establishment Clause kind of viewed the Establishment Clause and the Free Exercise Clause as being in tension with each other, where free exercise protects against government harming religion, but you can't be too nice to religion either because that might violate the Establishment Clause. I think the neutrality and now the non-discrimination posture to these clauses has a more holistic view of the First Amendment and says the Free Exercise Clause and the Establishment Clause are not in tension with each other. Rather, they point in the same direction and they work together to accomplish the same goal, namely to reduce government control and influence over religion. Free Exercise Clause says, government can't punish or restrict religion. That's one form of government control over religion. But it also says, when the government is out there, and we have a very large government today compared to what we had at the time of the founding. Government is very influential. It occupies a lot of land. It occupies a lot of money. And when the government is creating these programs and sending a lot of money out there and saying, hey, this money can be used for secular organizations and secular purposes, but we're going to cut it off if you try to use it for religious purposes, that actually has a major secularizing influence on the rest of society. Whereas this posture of non-discrimination, saying you're going to send a bunch of money out there for private organizations, it needs to be available equally to secular and religious organizations. That basically gets the government out of the business of using its money to push people toward more secular endeavors and says to the people, hey, you decide. Religion is up to you. It's up to the private sphere. We, the government, we're not going to be pushing you in one direction or the other. If you want to use that money at a secular school, go for it. If you want to use that money at a religious school, go for it. Religion is up to you. It's up to the private sphere. Second big takeaway from Carson, I think, is what lies on the horizon here. So let's assume that the Supreme Court says you can't discriminate based on religious status, can't discriminate based on religious use, the fact that you use the funds for religious instruction. I think the next big frontier is when governments say, all right, we'll let religious people have the funds, but you can't have the funds if you're doing bad things. So that's the government saying like, hey, you can use these funds at a religious school, but you can't use these funds at a religious school that discriminates. If you're discriminating, you won't hire people based on their sexual orientation, or if you're discriminating against the student body, you won't admit students, you're trying to impose religious codes of conduct. It's not your religiosity that bothers us, it's your bad discriminatory conduct. We're going to cut you out of the grant program. I think you're going to see a lot of cases post-Carson presenting that issue, and that's an issue the Supreme Court is going to need to grapple with in the years to come. So that's a quick high-level overview of what's at stake in Carson, the first case now pending at the Supreme Court. Second big case. Kennedy versus Bremerton. This is a picture of Coach Kennedy. He is an assistant football coach at a public high school in Bremerton in the state of Washington. And he had a practice. After the games, he would go to the 50-yard line as the students were making their way off the field. He would kneel down at the 50-yard line and say a short prayer, thanking God for how the game went. This practice of his started to garner attention. Some of the students started joining in. At least one parent complained, and the school district decided to put a stop to it. Told him to stop praying, particularly when students were around. Kennedy asked, well, what if I just pray by myself? School said, no, you got to stop praying after the football games, because if you keep praying, we might be in danger of violating the Establishment Clause. So when Coach Kennedy lost his job, he sued the school district and said, school district, by not allowing me to pray personally, silently at the 50-yard line after games, you are violating my free speech rights, and you are violating my right to the free exercise of religion. So he sued the school district. And the question is whether firing Coach Kennedy over his practice of prayer violates the free speech clause or violates the free exercise clause of the First Amendment, or on the other hand, whether the school was justified in terminating him for fear that allowing his prayer might have violated the Establishment Clause. There are three key questions in this case at the Supreme Court. The first question is, what speech or what practice precisely was Coach Kennedy engaging in or wanting to engage in going forward? This is really a factual dispute, and it's a very vigorously contested factual dispute among the parties. Coach Kennedy says, all I want to do, all I'm asking for, the religious accommodation I'm asking for is after the game, I want to go to the 50-yard line as players are leaving the field, kneel down, quietly say a prayer to myself, and then rejoin the team after the game. The school comes back and say, no, that's not actually what you're asking for, and that's not actually what you were doing. You were going to the 50-yard line in a very public way. There were students joining you there. You were praying with the students. You were religiously speaking to them, and we can't allow that to happen. So there's a fight over, even what religious practice is at issue here. Second key question is, once you figure out what practice Coach Kennedy wants to engage in, is that practice private speech or is it government speech? This matters because if it's private speech, it's at least entitled to some sort of protection under the free speech clause and the free exercise clause. On the other hand, if this is government speak, if the government is speaking here, then that brings in lots of concerns under the Establishment Clause and the separation of church and state. The legal test for resolving whether this is private speech or government speech is fairly straightforward. It comes from a couple cases, the Garcetti case and the Lane case. Question is, was this, quote, ordinarily within the scope of the employee's duties, unquote. So if it's ordinarily within the scope of the coach's duties, it's government speech. If not, it's private speech. The school says this was government speech. It was on company time. It was on the company premises. You had students around. So of course, it's within the scope of your employment and it's government speech. Coach Kennedy says, no, that analysis is far too broad. I mean, imagine I walk into the school cafeteria at lunch, sit down for lunch, bow my head and say a short prayer. I'm on school premises. I'm on company time. I have students around me, but surely just praying over my meal is not government speech. And that's basically what I was doing here. I was on the field, but it was after the game. The students are leaving. It's my own private prayer and it's private speech. Third question at issue in the case, once you figure out whether it's private speech or government speech, would the school allowing this speech somehow violate the Establishment Clause? The school says, yes, there's a very serious risk of violating the Establishment Clause here. You have a school employee on school property during a school event praying. If we allow that to happen, it looks like the school is endorsing religion. You also had students at time joining into this. maybe they felt coerced to engage in this, and that too might be a violation of the Establishment Clause. Coach Kennedy says, no, this is not an Establishment Clause violation. The Supreme Court has repeatedly drawn a line. Government religious expression, of course, may implicate the Establishment Clause, but when it's private religious expression, there's a long line of Supreme Court cases saying just tolerating private religious expression does not violate the Establishment Clause, and it has to be protected. So those are kind of the main legal questions and legal arguments at issue in Kennedy versus Bremerton. Zooming out, how can we expect this to play out? I do think there's something intuitive from that starting point of like a public school teacher walking into the cafeteria and privately praying over his or her meal. I think there's a strong intuition that that needs to be allowed. And I do think the Supreme Court is probably likely to rule in favor of Coach Kennedy. The question will be, how far is that ruling going to go? I think it's very open to the court to define his practice very narrowly and say, look, he's just kneeling privately at the 50-yard line. That's all he's asking for, and that's permissible. And the court can leave for another day some of those harder questions of, what if students want to join in voluntarily? What if it, looks more like a government function? I think what may be going on here is, in part because of that 1970s era strict separationism jurisprudence that we talked about in the Carson case, we have a number of court decisions from the Supreme Court suggesting that religion in public school is a very dangerous thing, and public schools need to be a largely religion-free zone. And it may be that the Supreme Court views the Kennedy case as a bit of an opportunity to push back on that and say, look, public schools, yes, you can never coerce or pressure children to engage in religious practices. That's forbidden, but we still need to leave room for teachers and students to engage in private religious practice as long as it's not coercive. So that may be something that the Supreme Court wants to reinforce here. So that's the first two cases, Carson and Kennedy. The third big religious freedom case at the Supreme Court right now is called Shirtless versus City of Boston. And the picture here on the screen is a picture of City Hall Plaza in Boston. You look in the lower right corner, you can see 3 flagpoles there. And Boston typically flies the American flag on one, the Massachusetts flag on the second one, and the City of Boston flag on the third flagpole. But 2 or 3 times a month, it allows private groups to hold a private flag raising event and raise their own flag on that third flagpole. It's the city's stated purpose for this program is to foster diversity and inclusion and celebrate the diversity of Boston's many communities. And over time, it's held almost 300 private flag raising events. And until this case, it had never once denied permission to hold one of those flag raising events. It flew many flags of different countries. It also flew flags of various private groups like Bunker Hill Association, Chinese Progressive Association, and Boston Gay Pride. Then along came a group called Camp Constitution. It wanted to hold a private event raising what it called the Christian flag, shown here with a red cross on a blue field. And it wanted to hold a private event celebrating the rule of law, religious tolerance, and the historic and social contributions of Christianity to the nation. The city official looked at this application, said, this is a religious flag, and said, no way. Flying your flag would make the city endorse religion and would violate the Establishment Clause. So Camp Constitution filed this lawsuit and argued that excluding their flag, excluding their private event and their private speech violates the Free Speech Clause. The law at issue here in some ways is quite similar to the Kennedy versus Bremerton case. You have the same key question, is everything flown on this flagpole government speech, or is the flagpole also a forum for private speech? If it's government speech, again, the Establishment Clause kicks in, and there may be concerns about government endorsement of religion. But if it's private speech, it's arguably protected by the Free Speech Clause and the Free Exercise Clause. The difference between this case and the Coach Kennedy case is we're no longer dealing with government employee speech. We're dealing with speech on government property in the Boston City Hall Plaza. And on speech on government property cases, the Supreme Court has developed a three-part test for deciding when is speech on government property turned into government speech. The two leading cases are the Summum case and the Walker case. And the three questions the court looks at are, number one, what's the history of the governmental use of this space? Number two, would the message in this space be ascribed to the government by a reasonable observer? And number three, to what extent does the government control the content of the speech that takes place here? So one is the history of the forum, two is, would it be perceived as government speech? And three, to what extent does government control the content? The government argues here that this is government speech. Boston says, we exercise control over what goes up on our flagpoles. This is flying right in front of City Hall. Anybody walking by would think this is government speech. The Camp Constitution argues, no, you're not controlling this at all. You had almost 300 applications and you never once denied one until we came along. And everybody knows these are private events put on by private groups, and the government is not controlling the content here. This case also was argued a few months ago. And I think conventional wisdom is, it looks like this is going to be a win for Camp Constitution and a loss for Boston, and looks likely that the court will hold this as a violation of the Free Speech Clause, mainly because you had almost 300 groups fly their flags without ever being denied. And then only denial came when a religious group wanted to fly the Christian flag. Justice Kagan, Justice Sotomayor asked the city during oral argument, why didn't you settle this case? And I'd be surprised if it's not 9-0 or 8-1. However, there are some harder issues lurking beneath the surface of this case, and the justices asked about those at oral argument. They asked, well, what if somebody wants to fly a swastika? What if somebody wants to fly the flag of the KKK? Surely the government has to be able to have some control over the type of speech that takes place in a government forum. And there are some difficult issues lurking there, but I think it would be pretty easy for the court to write a narrow opinion that doesn't feel the need to tackle those issues on those facts here. So that's Shirtless versus City of Boston. If we can just step back for one moment and look at how these three cases are related, Carson, Kennedy, and Shirtless, think of them as funding, football, and flags. They have some really important issues in common. All three involved a government-sponsored activity or a program. Government funding, government football, like a government event in a government school, or flag raising on government property. So you have the government out in the world doing some sort of activity, creating some sort of forum for private activity. And then the question in each case is, to what extent can or must religion be excluded or included in this event, particularly in light of the Establishment Clause? And then in all three of these cases, you have government officials, I would say, acting on a kind of old, outdated view, strict separationist view of the Establishment Clause, kind of that first era of Supreme Court jurisprudence, saying, hey, our funding can't go to religious groups. We can't allow religious prayer at a school event. We can't allow a religious flag to fly in front of City Hall. That would violate the separation of church and state. If these cases were arising in the 1970s, the government officials here would have a much stronger case. But the fact of the matter is Supreme Court jurisprudence on the Establishment Clause has shifted quite a bit. And I think some of these government officials are maybe a little bit slow to catch up to modern Supreme Court jurisprudence. And so I think you might see some cases some decisions that are kind of sending the message to government officials that, look, public spaces don't need to be religion-free zones. So those are the first three cases at the Supreme Court right now. That brings us to the fourth big case at the Supreme Court right now, 303 Creative versus Elenis. These first three cases that I talked about were free speech and free exercise versus Establishment Clause and like separation of church and state. This one is free speech on the one hand and the government's interest in non-discrimination laws on the other. So the facts. 303 Creative is a small business that wants to create custom websites to celebrate weddings. But the owner is a Christian who says she cannot, in good conscience, create websites celebrating same-sex unions. Under Colorado law, however, that is illegal. Colorado has what's called a public accommodations law, and it defines her business as a public accommodation and says that it cannot deny goods or services to the public based on sexual orientation. So the owner of 303 Creative says, hey, I want to enter this line of business, but under Colorado law, I'm going to be facing penalties if I enter this line of business and yet refrain from creating websites to celebrate same-sex weddings. So the owner of 303 Creative sued, said this is chilling my free speech, it's violating my free exercise rights, it violates the First Amendment. And the question is whether applying Colorado law in this way to require a small business owner to design a custom wedding website for a same-sex wedding, does that violate the free speech or the free exercise clause of the First Amendment? If you've been following these religious liberty issues over the last 3 years, this case might be ringing a bell. I was talking with someone and who said to me, wasn't this already resolved by the cake baker case? That's a Masterpiece Case Shop case from a few years ago, where the Supreme Court, it also arose in Colorado, where Colorado law was interpreted to require a baker to create a custom wedding cake to celebrate a same-sex wedding. In that case, the Supreme Court ruled 9-0 in favor of the baker on grounds of the free exercise clause, not the free speech clause. The free exercise clause said that the Colorado Human Rights Commission allowed anti-religious animus to influence its decision-making, and that violated the free exercise clause. The difference here with 303 Creative is it's no longer necessarily a free exercise of religion case. It's been litigated much more as a free speech case. And when you look at it as a free speech case, there are a few key questions. Number one, is creating the website a form of private speech protected under the free speech clause? The government in this case says no. This is a commercial business. Commercial speech is entitled to less protection under the First Amendment, or it argues that this is really discriminatory conduct. It's not speech. Or it argues if it is speech, it's not actually attributable to 303 Creative, it's attributable only to the same-sex couple that's getting married. So the government argues there's not really any speech here to be protected. 303 Creative, on the other hand, says, yes, of course this is speech. I mean, if I was writing a speech for a political candidate and they were paying me to write that speech, if I was creating a poem, if I was creating music, in celebration of same-sex wedding, obviously those artistic endeavors, those are forms of speech, and there are a lot of Supreme Court cases saying the creation of speech and artistic conduct for sale is still speech protected by the First Amendment. And yes, the speech is attributable to the couple, but it's also attributable to the maker. I'm in the midst of the process. I'm designing the speech precisely to celebrate the union. And so it's attributable to me as the maker of the speech as well. If the speech here is private speech, subject to protection under the First Amendment, the government is compelling speech, and the question becomes, does compelling that speech satisfy strict scrutiny? And there, the government has to show, number one, that enforcing its law in this way furthers a compelling governmental interest, and number two, that enforcing its law in this way is narrowly drawn to further that compelling interest. It's not restricting more speech than is necessary. The 10th Circuit, in this case, ruled in favor of the government, divided 2-to-1 decision. The majority said this is private speech. It is protected by the First Amendment, but the government satisfies strict scrutiny. It identified 2 different compelling interests furthered by this non-discrimination law. One is protecting the dignity of same-sex couples and LGBTQ individuals. The second compelling interest here is providing access to the marketplace for LGBTQ individuals and same-sex couples. Looking at those 2 compelling governmental interests, the majority said they're compelling, but then it rejected the first interest, the interest in protecting the dignity of same-sex couples, and said, yes, that's compelling, but as a legal matter, we've never held that protecting people's dignity is a reason for the government to restrict free speech. People engage in speech all the time that is highly offensive and hurtful, and yet the Supreme Court has repeatedly held that it's protected by the free speech clause. So just the fact that speech undermines somebody's dignity, causes offense, causes hurt feelings, that's not justification to restrict it. But the majority then turned to the second compelling interest, access to the marketplace, and said that applying this anti-discrimination law to require 303 Creative to make these websites, that is narrowly tailored to ensuring access to the marketplace for LGBTQ individuals and same-sex couples. And it made a very interesting move here, though. It defined the marketplace. It said 303 Creative, its services are unique and not fungible. And so it defined the relevant market as, quote, custom-made wedding websites of the same quality and nature of those made by 303 Creative, unquote. And it said, in that market, quote, in that market, only 303 Creative exists. So 303 Creative has a monopoly in that market. And therefore, the only way the government can ensure access for LGBTQ couples to that market is to make 303 Creative serve them as well and create websites for their weddings. The dissent, Chief Judge Temkovich, took issue with that application of strict scrutiny, said there's no compelling interest in ensuring access to a particular person's or a particular vendor's unique artistic product. We need to look at the marketplace more generally. Of course, same-sex couples have many website designers they can choose from, and the government has many narrower alternatives for ensuring access to the marketplace, short of compelling 303 Creative to provide this speech. So now the Supreme Court has agreed to take up the case. What can we expect from the Supreme Court? This one's going to be argued next term. Won't see a decision likely until 2023. I think interesting features of this case, it really squarely presents the free speech issues that were left open from the Masterpiece Cake Shop case. Since that was decided on free exercise grounds, this gives the Supreme Court a chance to really grapple with the free speech question. It also avoids one of the difficult line drawing problems in Masterpiece. There was a big fight over whether baking a cake was speech or not. The plaintiff said these are custom designed cakes designed to celebrate the wedding, so it's speech. The same-sex couple said this is not speech, you're just baking a cake. Website design is much more clearly across the line and is a form of speech. So it really squarely tees up the free speech question. It squarely tees up the strict scrutiny issue of balancing, how do we as a society balance, the interest of LGBTQ couples in not encountering offensive speech and full participation in the economic market versus free speech and religious liberty. A lot of helpful precedent on this from prior Supreme Court cases. If you want to look at the Hurley case about parades, the Dale case about Boy Scouts, or even last term, the Fulton case about foster care, all of those provide interesting insights into how the Supreme Court might balance those competing interests here. So that's 303 Creative, and that wraps up the 4 big cases pending at the Supreme Court right now. By way of reminder, if you have questions, feel free to shoot those via email to jeff@shieldsLawOffices.com. I think that email is in the chat. This wraps up the first part of my discussion. Now I'm going to launch into the second part. I want to look at a couple, just 2 lower court cases right now. But I picked those cases carefully because they exemplify some very significant religious freedom issues that may be bubbling up to the Supreme Court in the very near future. Full disclosure, these are cases where the Becket Fund is representing one of the parties. I'm involved in these cases, but I'll try to kind of give an even-handed description of what's at issue. The first case, currently pending in the 7th Circuit, is a case called Starkey versus Archdiocese of Indianapolis. I'll start off with the facts and then kind of explain what the legal issues are. So the facts here. The Archdiocese of Indianapolis runs a number of Catholic schools. And those Catholic schools ask their teachers and other educators to uphold Catholic teaching, including in their conduct. And they ask all their educators to sign a contract that includes certain behavioral standards of conduct and includes not engaging in sex outside of marriage between one male and one female. The plaintiff in the case, Lynn Starkey, was a guidance counselor at a Catholic high school. She signed that contract, but she entered a same-sex union in violation of the contract, and the school declined to renew her contract. She then sued the school and the Archdiocese, alleging employment discrimination under Title VII, which is the federal law that prohibits employment discrimination. She alleged that this was sex discrimination in violation of Title VII. Now, if this case had been brought 5 years ago, 10 years ago, it would have immediately been dismissed because at that time, Title VII, federal employment law, did not prohibit discrimination based on sexual orientation or gender identity. However, a recent case just a couple years ago, Bostock versus Clayton County, the Supreme Court interpreted Title VII and its prohibition on sex discrimination to also prohibit discrimination based on sexual orientation or gender identity. So as the Supreme Court has interpreted Title VII, it is now unlawful for employers to dismiss employees based on their sexual orientation or gender identity. So based on Bostock, this employee's claim, Starkey's Title VII claim, is allowed to move forward. The question then becomes, what religious defenses, what religious freedom defenses are available to the Archdiocese of Indianapolis? The first religious freedom defense, I'll put up a slide here just so it's easy to keep track. of what defenses are available. The first defense is a First Amendment doctrine called the ministerial exception. You may have heard of this. There have been a bunch of lower court decisions on it, 2 Supreme Court decisions on it. The first one was in 2012. And the basic idea of the ministerial exception is that religious organizations have a First Amendment right, rooted in both the Free Exercise Clause and the Establishment Clause, to decide who within the religious organization gets to carry out important religious responsibilities, like teaching the faith or leading the organization. And the Supreme Court has held that if an employee has important religious responsibilities, that employee is termed a minister, and that employee is not allowed to bring a lawsuit to get his or her job back. The religious organization has a First Amendment right, a unqualified First Amendment right to choose who's going to perform important religious functions. And the 2 Supreme Court cases on this issue, both of those were Becket Fund cases. Both involved teachers at religious schools. One of those was 9-0, one was 7-2. The Supreme Court held that these teachers at religious schools are performing important religious functions. They're teaching the faith to the next generation, so they qualify as ministers, and therefore they cannot sue to get their jobs back. That is the ministerial exception. In the Starkey case, the guidance counselor case, the lower court held that Starkey, like the teacher in these other Supreme Court cases, is a minister subject to the ministerial exception. Her contract expressly designated her as a minister. She is guiding students as a guidance counselor through some of the most important issues in their lives. Guidance counselors were expected to pray with students. Many personal issues came up, including issues of human sexuality, and the school expected guidance counselors to lead students through those issues informed by the Catholic faith. So the lower court held that Starkey was a minister, and her claim was therefore barred under the ministerial exception. But there are a lot of other cases in the lower courts today that don't involve ministers. So imagine for a moment that Starkey is not a minister. She's a part-time substitute math teacher or secretary or janitor. No clear religious responsibilities. Are there any other defenses that religious organizations can assert beyond the ministerial exception? And this, I think, is going to be one of the biggest issues litigated in the lower courts in the years to come, and is bound to come up to the Supreme Court sometime soon. I'd like to just lay out 3 or 4 or 5 of the key legal defenses beyond the ministerial exception. So if the employee is not a minister, what are the protections of that? First, Title VII itself, the very statute that prohibits employment discrimination, also includes a religious exemption. It's a protection for religious organizations. And it says, quote, Title VII shall not apply to a religious organization with respect to the hiring of, quote, individuals of a particular religion, unquote. So Title VII doesn't apply if a religious organization is hiring individuals of a particular religion. What does that mean? Courts have divided. Some courts construe that religious exemption very narrowly, and they say hiring persons of a particular religion. That means Catholic schools can hire fellow Catholics, but all other forms of discrimination are still prohibited. So if the plaintiff is suing you for sex discrimination, that exemption doesn't apply. That exemption protects you only if the plaintiff sues you for religious discrimination. Very narrow interpretation. Other courts interpret the religious exemption in Title VII more broadly. They point out that Title VII actually includes a definition of religion in the statute. It defines religion to include, quote, all aspects of religious observance and practice, as well as belief, unquote. So religion is not just a matter of belief, It's not just, do you label yourself a Catholic? It also includes observances and practices. So if an employer is hiring persons of a particular observance or practice, those people can't sue to get their job back. And so even if it's a claim of sex discrimination, as in Starkey, if the religious organization is saying, we're trying to hire persons of particular religious observance and practice, persons who adhere to our beliefs and practices on marriage, that is protected by the religious exemption. Very important issue, going to be very heavily litigated in the years to come, likely headed to the Supreme Court. A second defense that religious employers can assert is the Religious Freedom Restoration Act, or RFRA. This is a federal civil rights law passed by Congress designed to provide heightened protection for religious practices. And it basically has two parts. First, the religious party has to show that the government is imposing a substantial burden on their religious exercise. And if that is shown, the burden shifts to the government, and the government has to show that imposing that burden on religious exercise satisfies strict scrutiny. That's the least restrictive means of furthering a compelling governmental interest. So in cases like this one, like Starkey, the archdiocese would say, hey, forcing us to hire guidance counselors or secretaries who violate church teaching, that is a substantial burden on our religious practice. And forcing us to do that doesn't satisfy strict scrutiny. Courts are also divided over RFRA. Some have interpreted it narrowly. Some say it only applies to suits where the government itself is a party, where the government is directly imposing the burden. Others say that RFRA also applies to lawsuits between private parties, like an employee suing her employer, and also provides protection there. So that's another issue going to be heavily litigated. Those first two are statutory defenses. There are also constitutional defenses. One is what's called the doctrine of church autonomy. The basic idea here is the First Amendment protects the freedom of religious organizations to try to form religious communities around shared religious beliefs and practices. So the ministerial exception, which we talked about earlier, only applies to key employees with important religious functions, but allows religious organizations to fire them for any reason or no reason at all. It's a blanket protection. Church autonomy applies to a broader range of employees. We would say, it doesn't have to be a minister, but it's limited to where you actually have a religious reason for dismissing the employee, where you're saying, we're trying to form a religious community around this belief or this practice, and this employee is acting inconsistently with that. That's the doctrine of church autonomy, has not yet been as heavily litigated. Fourth defense beyond the ministerial exception is called the doctrine of expressive association. The leading case here is Boy Scouts versus Dale, decided by the Supreme Court in the year 2000. And there, the Boy Scouts had dismissed a gay scoutmaster and said, you can't be a scoutmaster because you would interfere with our ability as the Boy Scouts to communicate the message we want to communicate about human sexuality. The scoutmaster sued under a non-discrimination law, said you're discriminating against me based on my sexual orientation. And the Supreme Court ruled 5-4 that non-discrimination lawsuit was barred by the free exercise clause under this doctrine of expressive association, with the basic idea being, hey, the Boy Scouts, it's an expressive group. It's designed to communicate a message. And if the government can force them to include people in their group that undermine their message, that could violate the free speech clause. And so in these religious employer cases like Starkey versus Archdiocese of Indianapolis, the argument by the religious group is, hey, we are an expressive association too. We formed this school to transmit the Catholic faith to the next generation. If you force us to include employees in our school that undermine the message we want to teach, that violates our First Amendment rights, our right to form an expressive association. So those are some of the key religious freedom defenses beyond the thoroughly litigated ministerial exception. These are bubbling up. I'm actually working on 5 of these cases right now in the lower courts. A lot of these cases have been unleashed by the Supreme Court's decision in Bostock, and I expect these will filter up to the Supreme Court sometime soon. I want to make sure there's plenty of time for Q&A, so I'm going to hit this last genre of cases very quickly. This is the second and last lower court case I wanted to talk about. It's called Apache Stronghold versus U.S. Forest Service. The picture here is a place called Oak Flat. And since time immemorial, since before European contact, Western Apaches have worshiped at this sacred site, in English called Oak Flat. It's on the National Register of Historic Places. It's the site of core religious ceremonies for the Apaches that can't take place anywhere else. They compare it to their Mount Sinai, like Mount Sinai for the Jews. This is like the starting point of their entire Western Apache religion. Been protected for many years. Recently, mining companies discovered a large copper deposit, thousands of feet under the surface of Oak Flat. And they lobbied Congress, which passed a law that will transfer control over Oak Flat to a foreign-owned mining company. And the mining company is going to create a vast underground mine, extract the copper, and it will collapse the surface of Oak Flat in a massive crater. It will swallow Oak Flat entirely. It'll be gone, and the religious practices will never take place there again. Apache Stronghold is a group of Western Apaches and allies. They have sued the U.S. Forest Service to stop the land transfer and destruction of Oak Flat. Their lawsuit is based on the Religious Freedom Restoration Act, that federal civil rights statute I talked about earlier, where there are 2 parts to the claim. One, has the government imposed a substantial burden on religious exercise? And then 2, if so, can the government show that imposing that burden satisfies strict scrutiny? In Apache Stronghold, you've had some lower court decisions that have tended to construe the Religious Freedom Restoration Act narrowly in sacred site cases. And the government's argument in this case is that substantial burden, that term substantial burden in RFRA is a term of art, and it only applies to 2 types of government action. Government penalties, like when the government fines you or imprisons you, or number 2, the denial of government benefits, like if the government has some big program, like they're giving out unemployment benefits, and they take those benefits away from you because of your religious practice. The government says those are the only 2 types of government actions that qualify as a substantial burden. And here, the government is not punishing the Apaches, it's not fining them or putting them in prison. And number 2, it's not withdrawing a benefit like funding or something like that. The plaintiffs in this case, who I'm representing, say this interpretation of substantial burden makes no sense. It means the government could post a sign outside of Oak Flat that says no trespassing, and fine the Apaches $1,000 for trespassing, and the government would say that's a substantial burden on your religious exercise, even though they can still engage in religious exercise there. But if the government hands the site over for complete destruction, obliterates it, swallows it in a crater, and you can never engage in your religious exercise again, that somehow is not a substantial burden on their religious exercise. Makes no sense. That case has been argued at the Ninth Circuit. I think if the Ninth Circuit goes the wrong way and interprets the Religious Freedom Restoration Act narrowly, that will be a very attractive vehicle for the Supreme Court to ensure a proper interpretation of the Religious Freedom Restoration Act. I want to leave time for Q&A. Third, I just wanted to zoom out very quickly here at the end, kind of say what's going on here in the big picture. Number one, I want to point out a few trends. Number one, I talked about this a little bit earlier, it's kind of cleaning up the remnants of the old Establishment Clause jurisprudence. I call it the lingering limits of lemon, that strict separationism that has infiltrated a lot of government officials, that kind of stays in that mindset. I think the trio of cases we discussed, those first three cases on funding, football, and flags, I think the Supreme Court is going to clean up that kind of old lingering Establishment Clause jurisprudence and make clear that public spaces don't have to be, public spaces and public places don't have to be religion-free zones. A second big area the Supreme Court is moving is on the issue of gay rights and religious liberty and the potential tension between those two issues. It had the Masterpiece decision in 2017 on the cake baker. It had the Fulton case in 2021. That was a Becket Fund case where City of Philadelphia tried to shut down a Catholic foster care ministry because of its religious beliefs about marriage. Both of those cases were 9-0 victories for the religious plaintiff. It's taken the 303 creative case on the website design for next term. And I think it's eventually going to take a case like Starkey versus Archdiocese of Indianapolis, one of these religious hiring cases that presents the tension or potential tension between gay rights and religious liberty. And I think the court is really wanting to make good on some of the promises it made in Obergefell and Bostock, where the court made created major protections for gay rights, but then said in that decision, we still respect religious liberty. We still respect the fact that many people still hold a different view of marriage, and we think they should be protected. The question in these cases really is the Supreme Court going to let the government pick one side of that debate over marriage and crush everyone who disagrees? Or is it going to try to protect the liberty of both sides and say, yes, you can have a marriage. Yes, you can get wedding design for your marriage, but no, the government can't force religious objectors to participate in that. A third big area where the Supreme Court is moving is possibly overruling Employment Division versus Smith. That's a major free exercise case. I don't really have time to get in that. Then a fourth area I think is exemplified by that Apache Stronghold case, and that is ensuring that federal civil rights laws like the Religious Freedom Restoration Act or its sister statute, the Religious Land Use and Institutionalized Persons Act, really provide robust protection for religious minorities as well. And then finally, some people, kind of ask me where I see the court going on religious freedom. I talk to a lot of audiences that are very worried about religious freedom, and I think there are reasons for concern, but I like to sometimes show folks where the court has gone on religious freedom recently. And since 2010, the Supreme Court has decided 20 religious freedom cases on the merits. And ask yourself, how many of those were victories for religious freedom? 20 cases since 2010. 19 out of those 20 cases, the Supreme Court ruled in favor of religious liberty. These 20 cases span all the major constitutional and many of the statutory doctrines: free exercise, establishment, autonomy, free speech, protections for multiple faith groups: Christians, Muslim, Jews, Buddhists, and others. And a lot of people think to yourself, how many of those 19 cases were closely divided 5-4 decisions? Is the court divided on religious liberty? Only 4 out of those 19 cases were 5-4. 15 out of those 19 cases were either unanimous or supermajority decisions. This is the list of those 19 cases. And I think it just shows that we have a Supreme Court that is very much committed to protecting religious liberty. and that the issue of religious liberty at the Supreme Court is not as divisive as it's often made out to be. There's a strong majority at the Supreme Court that wants to protect religious freedom. With that, I look forward to your questions. Again, you can send them to jeff@shieldsLawOffices.com. Also, sorry, my publisher would kill me if I didn't mention, I did publish a book, as Jeff mentioned. The title of the book is Free to Believe, The Battle Over Religious Liberty in America. It's less lawyerly and less legalese than I've given in this presentation. It's pitched for non-lawyers, but very helpful for lawyers as well. Basically, why does religious freedom matter? How is it threatened? And how can we protect it? You can get it Amazon, anywhere books are sold. And you can also find out about all these cases I discussed on Becket Fund's website, which is www.becketlaw.org. So with that, I'll turn it over to Jeff for questions.
Thank you, Luke. And we do have a number of questions we'll try to get through. We've got just under 15 minutes to try to tackle them. The first two go to the Kennedy case, okay? And the first one's an interesting one here. It's kind of factual. It's does student testimony get involved? Is this an area where compulsion or susceptibility to compulsion, for example, a player saying, if I do or don't pray with the coach, does that affect my playing time? Did those issues come to play at all in the case? And then the second question, well, why don't you go ahead with that, and then I'll go to the second question on Kennedy.
Okay, great. Excellent question. That issue is very much present in the briefs of the case. And it kind of gets at that first issue in the case I flagged, which is what is the practice that Coach Kennedy actually engaged in or wants to engage in? The school district very much highlights that students did sometimes participate in those prayers or join Kennedy while he was praying, and try to argue that that's an inherently compulsion-ridden environment where there would be fear about loss of playing time. Coach Kennedy comes back and says, look, I'm not asking to participate in prayer with the students. There's no record evidence that anybody ever was compelled or felt compulsion. And if it ever came to that, yeah, obviously, if a coach is docking your playing time because you're not praying, that's a violation of the Establishment Clause, but that's not what's at issue here. So yes, that's at issue in the case. That's a very important issue of doctrine. My guess is that based on the record the court has before it, it won't have to necessarily wade into that question of compulsion.
So the second question, thank you. The second question on the Kennedy case is Kennedy's prayer, essentially his expression of his faith in that respect in a public forum, is that really any different than a teacher standing at a lectern in the school who's wearing a religious symbol, such as a cross, a yarmulke, a hijab, or something like that? And again, not preaching or anything else, but it's an obvious private expression of faith, but in a public forum, public setting.
Yeah, another great question. And that precise example has made its way into the briefs in the case. What about a teacher who stands at the front of the class and has visible religious garb, a crucifix, a yarmulke, a turban, and so forth? And I don't think anybody would say that that is a violation of the Establishment Clause. And I think most people would agree that telling a public school teacher you're not allowed to wear a crucifix, that would raise serious free exercise issues. What the school district is saying here is, well, that's different because you're not actually engaging in a religious proselytization. This sort of when you're on the field after a game, you're a coach, kids are around, you're engaging in a religious practice of worship, and students might even be able to join into that. The school district says that's different. So that's kind of how that argument plays out in Kennedy.
The next question relates kind of to both the Carson case and the Starkey case. Again, school issues here. And it says essentially, is there a prohibition or is it any kind of restriction on a religious school hiring only teachers of one religion? Would that factor into either of those cases? In asking that question, I think I should note that I just saw that you were quoted not long ago, because again, as you noted, that you're the attorney waging the battle on the Starkey side on the Starkey case. And I'll just read for the group's benefit. This was the quote that the media had. It said, quote from Luke, "If the First Amendment means anything, it means Catholic churches can ask Catholic educators to support Catholic teachings," close quote. So that might inform what your answer is going to be on this.
Yeah, let me start with the freedom of religious groups. I do think there is a constitutional protection for religious organizations to hire only co-religionists. If you say we're a Catholic organization, we want to hire only Catholics, I think that's almost certainly protected by the First Amendment. Most courts haven't even had to get that far, though, because of Title VII, that the federal law that prohibits employment discrimination. It has that religious exemption that I talked about, and it says Title VII doesn't apply to religious organizations with respect to hiring individuals of a particular religion. And one of the leading cases there, I didn't talk about it, is called Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints versus Amos. That was a case where Church of Jesus Christ had a gymnasium, and it hired a building engineer. Plaintiff called himself a janitor, not somebody with significant religious responsibilities, but it dismissed him when he lost his temple recommend, which is basically his certificate of good standing within the Church of Jesus Christ. And he sued for religious discrimination and said that firing me for my loss of my certificate of good standing in the Church of Jesus Christ, firing me on that basis is discriminatory, and this religious exemption violates the Establishment Clause because it promotes religious faith. In the Amos case, the Supreme Court ruled 9-0 that this religious exemption is at least constitutional, like it doesn't violate the Establishment Clause, it doesn't overly favor religious groups to say you have a right to hire people of the same faith. Court didn't quite go so far as to reach the question of whether that statutory religious exemption is required under the Free Exercise Clause. I think it probably is, but the bottom line is religious organizations are on very safe ground when they say we're only going to hire people of the same faith. You asked about that question in the context of Carson as well, the funding context. And I think you could see governments saying, all right, we know we can't just ban all religious groups from our scholarship programs, but we might want to ban religious groups if they engage in discrimination. One form of discrimination could be not hiring teachers in a same-sex union. Another form of alleged discrimination could be, refusing to hire any teacher that's not a member of the Catholic Church. So could the government yank funding? Could the government exclude religious groups from funding on the ground that they discriminate in their hiring? And I think there's actually an OLC opinion. The Office of Legal Counsel for the Department of Justice issued an opinion on this, at least in the context of the federal government. It's called the World Vision opinion, and said that stripping federal funding from a religious group like World Vision because it only hires fellow Christians, that would violate the Religious Freedom Restoration Act. So that's one data point on that. Leaves a lot of open questions. What if it's not the federal government, so RFRA doesn't apply? What if it's not, you're not targeting discrimination based on religion, you're targeting discrimination based on sexual orientation? Those are still open questions. I do think those may get litigated, especially the question of yanking government funding for alleged discrimination based on sexual orientation or gender identity. But great question.
Thanks. Try to get several questions to you real quick here. We've only got about 5 minutes left, but some very interesting ones. So here's one. Is there, this is to one of the particular cases you've talked about, but has the law developed the idea that either atheism, secularism, progressivism or similar doctrines, that they have adopted essentially such characteristics of a religion themselves that the government essentially is violating the Establishment Clause by promoting them?
Yeah, short answer is no. That argument has been tried many times in litigation, saying the government has essentially adopted the religion of secularism and that violates the Establishment Clause. As far as its reception in the courts, it's been pretty much uniformly rejected.
Next question. This goes to kind of the school voucher equal access issues. Is a denial of that has the argument of taxation without representation been raised in that context? So in other words, the government's providing school vouchers but not allowing them to go to religious schools and so forth. Is that effectively a taxation without representation issue?
Yeah, no, I don't think it's been pitched as a taxation without representation issue. It's been pitched more as a, you're disqualifying me as a religious individual from accessing this government benefit or this government program because of my religious faith, and that violates my free exercise rights.
So the next question is from someone who says they read your book, and thank you very much. So that's good. The question is this, kind of maybe a forecast. There's been thousands of denials of religious accommodation under RFRA relative to military vaccine requirements. Is there any kind of a chance that one of those many cases is going to go up and is going to get taken up at a higher level, and particularly a U.S. Supreme Court level?
Yeah, great question. Vaccines are obviously an important issue. I kind of bracketed those from my remarks because last year's session on this was devoted to COVID. But I'd say there's basically three kind of buckets of vaccine cases right now where there are some types of religious objection at issue. One I think of as private employer mandates. So think like United Airlines saying all of our employees must get vaccinated. And some employees say, I have a religious objection to the vaccine. Those cases are typically brought under Title VII, saying this is employment discrimination based on my religion because you're not accommodating my religious objection. The second bucket of cases I think of as federal government mandate cases. This is where the federal government itself is saying some group of people have to get vaccinated, like the OSHA mandate, the CMS mandate, or the federal contractor mandate, or members of the military must get vaccinated. Most of these cases have been brought less as religious liberty cases and more as cases challenging the scope of federal authority, like the OSHA case that went up to the Supreme Court. But in the military context, there are a number of cases challenging military requirement of vaccination as a violation of RFRA, the Religious Freedom Restoration Act. There's actually one of those cases has already produced an injunction in favor of military service members with a religious objection to vaccines. That's Austin versus US Navy SEALs. The federal government went up to the Supreme Court, got a partial stay of that injunction, but most of the injunction remains in place. That's kind of the federal government mandate bucket of vaccine cases. And then the third bucket of vaccine mandate cases are what I think of as state and local government mandates. So think of like New York State saying all healthcare workers must be vaccinated. Or think of the San Diego School District saying all students in public schools over the age of 15 must be vaccinated. So state and local governments imposing vaccine mandates. These have also been challenged. Usually the religious challenge is under the Free Exercise Clause, and those have produced somewhat mixed results in the lower courts. Main issues here are, number one, you got to look out for sincerity in the vaccine mandate cases. There is an issue of taking a political view and trying to assert it via the means of a religious objection. If that religious objection is not sincere, that case should lose. But when an objection is sincere, some of these objections involve, the fact that some of the testing was carried out using cells derived from aborted fetuses. There are some sincere religious objections to the vaccine mandate. There, the courts are going to be looking at, how uniform is this mandate? Does it apply to everybody? Are there big exemptions? It's going to be looking at how common is this sort of mandate? And like, if New York imposes a mandate, but 47 other states don't impose that mandate, is New York's mandate really necessary? And it's going to look at strict scrutiny defense by the government. So that's kind of an overview of the vaccine state of play.
Thank you for that. And unfortunately, we've exhausted our time. We've got other questions. I know. I apologize that we weren't able to get to all of them. But we've all been enriched and enlightened quite a bit by our great speaker here, Luke Goodrich. So if you could, again, at least by way, maybe show, hey, we appreciate that. Thank you very much. Luke, it's been a delight to have you here with us. All of you, thank you so much for joining us. Again, this year, we hope to be back both live and Zoom next year, hoping that the health circumstances accommodate that. Likewise, if you want the MCLE credit, please send either me an email or just respond to the Zoom email that you got with the link, and we'll make sure you get that too. It's a delight to have everyone here and to share in these very important conversations and on this very important subject matter. Thank you again for your attendance and our co-sponsors for their sponsorship. And we'll let all of you go. And Luke, we'll look forward to seeing you again, hopefully sometime soon.
Thanks, Jeff. Thanks, everyone.